Gill versus Whitford is a case that attempts to answer a question that's about 30 years old. How do you define a gerrymander? Gerrymandering is a way to draw district lines to help your party and hurt your opponent. The term gerrymandering is based on the name of a founding father named Elbridge Gerry. Elbridge Gerry created a prototypical gerrymander in Massachusetts that was lampooned in a cartoon in 1812. It looked like a salamander. It wrapped around the district that was to be divided up. So when you make a portmanteau word of salamander and Elbridge Gerry's last name, you get gerrymander. Gerrymandering has been practiced by both parties at least since the original gerrymander in 1812. In a gerrymander, the object of the game is to make the other party lose more seats. In most states in this country, district lines are drawn by state legislatures, and state legislatures, of course, are peopled with partisans. What the technique involves is to take your opponent's partisans and stack them in just a few districts where they win overwhelming majorities so that your party can win more seats by smaller majorities. This dispute has roots back to 2011. In that year, the Republicans won both houses of the Wisconsin legislature and the Wisconsin governorship for the first time in 40 years. They proceeded to draw new districts. These districts were a classic gerrymander. They were designed to hurt the Democrats, and they did. In 2012, with 49% of the vote, the Republicans managed to garner 61% of the seats in the Assembly in Wisconsin. So with a minority of the votes, they managed to get a majority of the seats. The next season, in 2014, the Republicans won 52% of the votes, so they did have a majority, but they garnered 64% of the seats in the legislature. What the parties in this case claim is that the wasted votes, their party, the Democrats, so exceed the wasted votes of the party that drew the lines, the Republicans, that there's a constitutional violation. According to the plaintiffs, and according to a lot of social scientists who agree with the plaintiffs, a wasted vote is basically any vote cast by a majority, which is greater than 50% plus one that's needed to win. It's wasted in the sense that it's not necessary. It's also any vote cast by the losing minority, which is basically all the votes that they cast in a district where they lose. Now, it's very clear under Supreme Court constitutional law that there is no right to proportional representation. No one in this country has a right for their party to get 60% of the seats because 60% of the population voted for it. Well, if that right doesn't exist, then how can this case go forward? Because what the plaintiffs have done is say that people have a right to a sort of altered proportional representation based on their estimates of what the parties should win if things were fair. And this, in the view of some, in my view, is piling improbabilities on top of improbabilities. How does one define what parties should be expected to win in a hypothetical world where there's no gerrymandering? There's no clear answer to that question. What happened in this case in the district court was that by a 2-to-1 margin, the district court accepted the plaintiff's claim. They said that the Constitution is violated with the intent to severely impede or impair the effectiveness of voters' votes on a basis of their affiliation with other voters. If the Supreme Court goes along with the district court's ruling, it would result in an explosion of litigation. Those cases would be ugly and contentious and difficult to resolve because there's no clear test coming out of this case to say exactly what one looks at in saying that one set of districts is a gerrymander and the next set of districts is not. Every district line is put down with an intention. So how do you distinguish between extremely bad gerrymandering that violates the Constitution and run-of-the-mill gerrymandering where you're trying to hurt your opponent, which is what everyone tries to do?